All right, good morning and welcome to the District of Columbia Court of Appeals. I'm Chief Judge Blackburn Rigsby, and I'm joined this morning by Associate Judge Vijay Shankar and Senior Judge Washington. We have one specially set matter this morning in the matter of GD v. United States. We are using initials because we will be referring to juvenile records in this case. Counsel, are you ready to proceed?
Good morning, and may it please the court. Sarah McDonald on behalf of appellant GD, whose family is here in the courtroom today, in addition to family members who are streaming the argument live this morning. Before I begin, I'd like to reserve 3 minutes for rebuttal. Judge Anderson's order denying IRA relief contains a litany of factual and legal errors, but I will focus on what I think is the simplest one and the one that looms the largest, which is the Bryant error. Judge Anderson's over-reliance on GD's youthful criminal history requires reversal under this court's recent decision in Bryant versus United States, which postdated the briefing in this case, but was the subject of our 28K letter. Bryant held that the court there put too much stock in teenage arrests and convictions, and that is only more true here. Judge Anderson called GD's substantial juvenile criminal history a, quote, significant negative, and it was the first reason she gave in explaining why, in her view, GD had not met his burden on the dangerousness prong.
One question I have that makes this order of the trial court somewhat difficult to decipher is that she weighs a number of factors in favor of release under IRA, and then ultimately concludes that the lesser number of factors against release justified not releasing him. How are we supposed to balance that? There were a number of factors that weighed in favor of release. How do we know, as you say, that she weighed this factor most heavily?
I think there's actually only one factor in the order that Judge Anderson is explicitly saying weighs in favor of relief, and that's the factor relating to the victim statement. I think she does say in the dangerousness analysis, while there are some factors that weigh in favor, there are, quote, significant negatives. I think it's not entirely clear that that means that she's weighing entire factors in GD's favor. And I think when it comes to criminal history in particular, there's really no question, and the government hasn't disputed, that that played a significant role in her bottom line to deny relief. It's the first reason she gives as a significant negative in the dangerousness analysis, and it's really the heart of her factor 2 analysis under the history and circumstances, where she sort of says, I understand that there are somewhat, in her mind, conflicting views of the childhood, but what is not in dispute is this significant juvenile criminal history, this, quote, astonishing number of contacts with the criminal justice system. And those contacts include charges that plainly did not result in conviction or disposition, charges that were dismissed.
Counsel, so you used the word over-reliance earlier, and I know that that's language from Bryant, and so that's the plane we're operating on. But it seems like one argument could be that no prior criminal history before the offense of conviction should be considered in this context. Another argument could be that at least no juvenile criminal history should be considered at all. And so I'd like to flesh out what your position is and why you're talking about over-reliance, because that makes it a little fuzzier, right, for trial courts and for this court to figure out what the trial court can do. And I wanted to point you specifically to one piece of your reply brief where you said you don't dispute that a juvenile criminal history can serve as a baseline to determine what type of rehabilitation the trial court should expect from the inmate. And so how do you see that working in practice? It's a lot of questions there.
Yes, I think in light of Bryant, this court actually doesn't need to fully delve into those questions. I think if the court, Bryant, as Your Honor noted, is talking about over-reliance, and when comparing the underlying order in Bryant with the underlying order here, there's really no question that there is heavier reliance on juvenile and youthful criminal history in this case than there was in Bryant. It's true that Bryant doesn't take off the table the possibility that a court could consider in some way juvenile criminal history. But I think what Bryant comes back to is the fundamental premise of IRA, the recognition that, juvenile patterns, youthful acts are not predictors for dangerousness in the present. And I think that's
But
really—
under IRA, a trial court can consider the underlying criminal offense that resulted in the incarceration. And so I guess as a follow-on to Judge Schenker's question, what was wrong with weighing as one of the factors the underlying offenses here, and noting that there were numerous offenses as a juvenile and then infractions while incarcerated after reaching the age of adulthood?
In Bishop, this court has said too that when it comes to the underlying offense itself, over-reliance is also a problem, right?
But what is over-reliance? What an example of reliance versus over-reliance? Because are judges supposed to completely ignore the underlying offense?
And as I said, I think this case doesn't actually present any difficult questions about what constitutes over-reliance. We know that Bryant constituted over-reliance, and I think comparing this case to Bryant is helpful. In Bryant, the factor 2 analysis that the trial court engaged in was actually more nuanced, sort of went through, on the one hand, Mr. Bryant had this suburban middle-class upbringing, described his childhood as good, his father's alcoholism was the negative. I understand that his father's alcoholism had a negative effect and is sort of a mitigating circumstance in Mr. Bryant's youthful criminal history, but the court in Bryant still weighed factor 2 against Mr. Bryant because of the juvenile criminal history here. Here, I think we have really the same thing under factor 2, where the trial court is saying sort of set aside whatever other picture we have of GD's childhood. What is not in dispute is the significant number of contacts. And again, she's focusing on contacts, not just actual convictions.
So that's how you would distinguish the issue of the characteristics of a defendant from his juvenile record in terms of the analysis under the IRA? Because factor 2 clearly talks about the characteristics of the defendant and how better to understand or know sort of that person's character than by looking at even perhaps juvenile offenses.
Yeah, and I think that's why Bryant says we're not saying that this is a completely irrelevant factor, but even just treating it as dispositive under factor 2, which the trial court's analysis in Bryant of juvenile criminal history was really limited to factor 2. And the court said even treating that as dispositive under factor 2, given the purposes of IRA, right? Given that IRA is about acknowledging the diminished culpability of children and their capacity for rehabilitation, even that is error. Here, the reliance on juvenile criminal records goes beyond the factor 2 analysis. Under factor 4, the trial court is sort of discounting the government's assessment that this case presented a close question, saying the government didn't have full access to the documents underlying the juvenile record. Under factor 5, which talks about demonstrated maturity and rehabilitation, Judge Anderson is saying GD's significant criminal history gives the court pause.
Can I ask a question about factor 5? One of the things that was a little puzzling in the record to me is that GD's pattern score, which is the test used to assess likelihood of recidivating and reoffending on release, was low. Meaning that he was a low risk to commit crimes on release. But the record keeps referring to his medium risk and the fact that he was placed at a medium risk prison facility as opposed to a low risk prison facility. And I'm wondering if that's not an error that you seem to dwell on in this record, but it was something that was puzzling and concerning to me.
I certainly think that the failure to acknowledge the low pattern score, especially given how central that was in GD's pleadings, is a problem. I actually think that the low pattern score and the medium classification of the institution are two separate things. So that is not itself an error. But what is an error is that one of the things that the trial court is relying on repeatedly is saying there are these identified needs by the BOP. One of these is in sort of substance use, but those needs, as we've pointed out in our briefing, go hand in hand with the pattern score. So under the First Step Act, the risk and needs assessment is composed of two things, both the pattern score, which identifies the risk of recidivism. GD's is low, a category in which 92% of people do not recidivate in any way. And then along with that, there is the needs assessment. And what the needs assessment does is show targeted areas that could reduce the risk of recidivism. So when the court is talking about the needs as sort of things that GD would need to be released, that's the wrong way to think about it because of the low pattern score. The needs are areas that could further reduce this low risk of recidivism. And so in that way, I think both there is error in the way that the court was talking about the needs, which is not the way that the government didn't rely on them in that way in the trial court, and coupled with the failure to acknowledge the pattern score, that is a further error in the judge's order.
I just want to go back to, I think, something I mentioned earlier, which is a point in your reply brief that says the court that juvenile history, or at least prior criminal history, can be relevant as a baseline for rehabilitation. How is that different from what the court here ultimately said about the prior criminal history, including the juvenile history, which was based on that? And I realize the court said a lot of other things about it, but one of the primary things it said was based on that, GD has not engaged in the level of rehabilitation that I think is necessary. Isn't that kind of exactly what you said is permissible? And when else, what else, why can't a court consider that with respect to rehabilitation?
I think that we have acknowledged that sort of juvenile criminal history can be a baseline to show how far someone has come. And I think that if the sort of higher demands that Judge Anderson seemed to put on GD's programming were sort of because of the juvenile criminal history were the only way that she were using it, it's possible that that would be a different case. But she's also talking about it in terms of sort of the astonishing number of contacts, the worry that he's going to fall into familiar patterns. And those at least are plainly, after Bryant,
Did you say
ways of using
higher demands or prior demands? I misheard you.
I think higher.
I think I said higher.
Higher demands, like getting the GED, like are those what you mean by higher? Because she did find an issue with the fact that he hadn't taken advantage of what she said were opportunities to get his GED and to take more classes and credits. Is that what you mean by a higher demand? Because that's not an unusual question that we see that trial judges evaluate when they're looking at likelihood of recidivism.
Or I think, again, with sort of the failure to even acknowledge the low pattern score, the low likelihood of recidivism, that's different. And when it comes particularly to the GED was framed in terms of a concern about gaining employment upon release, whereas there was, as the trial court acknowledged, a release plan that included a concrete offer of employment. But when it goes back to sort of the question of the programming demands here, I think both my response would be the use was much broader, and I think clearly fell into ways of viewing juvenile criminal history as a predictor of behavior on release as an adult that are plainly impermissible under Bryant and under the fundamental premise of IRA. And then also when the court is saying, so there are sort of more programming needs to be done. Again, that is infected by this sort of failure to understand what the needs are. And so she's relying on, these are the needs that the BOP identifies. But again, those are really just, these are ways that he could reduce his risk of recidivism even further.
Can I redirect you to, in your remaining time, to the Innocence Protection Act issue? And I'll just leave it like that.
Yes.
The fact that one of the witnesses recanted and the trial judges expressed concerns about that.
Yes, and I want to just start by saying that the government has never argued here that the interest of justice analysis or the focus on the IPA litigation is an independent basis for affirmance. I think the interest of justice analysis is also plainly infected by these Bryant errors. But when it comes to the concerns about IPA litigation, Judge Anderson framed her concerns in terms of committing perjury by signing this affidavit swearing innocence in the IPA litigation. The government has never defended the characterization of that as committing perjury. And then she talks about suborning perjury by presenting Mr. Scott's testimony, and the record really can't support any connection that would be necessary to draw conclusions about subornation of perjury, the connection between GD and that recantation or anything like that. And
That'd be enough?
Sorry.
If there was evidence of the suborning perjury, you wouldn't be arguing that the interest of justice analysis couldn't consider that, correct?
I think there would still be problems with sort of treating it as a standalone factor post-Doe, but I'm not saying that if there were actual perjury somewhere in the record, that is totally an improper thing to consider under IRA. I'm saying what we have here is someone who has consistently maintained his innocence. And what the trial court's logic really does is pitting someone who has maintained their innocence, including by pursuing IPA litigation, against IRA relief. Anytime someone pursues IPA litigation, they swear this affidavit affirming their innocence. GD, unlike actually these other cases that the trial court was talking about at the intersection of IPA litigation and IRA relief, is not someone who's ever gone back on that assertion of innocence. He has maintained it consistently. The evidence against him at trial was purely eyewitness testimony, mostly stemming back to Mr. Scott, who is now recanted, to Mr. Scott's identification. And so, especially in the face of a statutory scheme where the council declined, as we pointed out in our briefing, to make acceptance of responsibility a factor under IRA, even though similar statutes include that as a factor, even though the express model for IRA includes that as a factor, the council recognized that innocent people are convicted. And as we've quoted from then Judge Chief Morin, it didn't intend to preclude IRA relief for people who maintain their innocence, but still pursue and achieve rehabilitation in prison as GD has. And so I think the logic of the way that the court used the IPA litigation here is flawed. The conclusions about perjury and subornation of perjury are unsupported by the record.
So is your position here that the reference to perjury as effectively a standalone crime was the error? Or is it a broader argument that any reliance on a defendant, an inmate having made an IPA application, which necessarily asserts actual innocence, and necessarily if it's rejected, if it has been rejected, at some level it involves a suggestion or an implication that the defendant presented some sort of false evidence of their innocence, that should never be held against the defendant in an IRA case?
My position doesn't go as far as it should never be held against a defendant in an IRA case. I think that what is particularly the root of the problem here is the characterization of what happened as perjury. But I think that's also significant because at the same time as Judge Anderson is saying, I recognize that IRA sort of doesn't require acceptance of responsibility. That's not what I'm asking of someone. The reason in her mind that the IPA litigation is still a count against GD is because she views what happened as perjury. So that is unsupported by the record. And that sort of takes out the whole premise of why she was even relying on that. But then as a broader point, I think that because of the nature of IPA litigation, there is a problem with judges saying it is not in fact true that she's not treating this as kind of a requirement of accepting responsibility. And the logic underlying the way she talks about the IPA litigation would pit IRA and the IPA against each other in the way there's really no indication that the council intended.
But if the court, based on the history, case history, now faced with an IRA case, says, you know, this denial, this sort of false claims that the appellant is raising is an indication of a lack of maturity, is a lack of rehabilitation. Would that be appropriate to say that, you know, putting forth these false claims in this IPA, not perjury, just these false claims, because we found that at least the trial judge didn't abuse its discretion in finding that, you know, there was sufficient evidence to find that the recantation was not genuine. Is that, again, something that would be allowed under the IRA?
I won't say that it's a categorically impermissible factor. I do think in this particular case, the characterization of what happened as perjury is so infecting the entire discussion of it that I think that this court doesn't really need to reach questions about a situation where it might arise in a more nuanced manner. I still think there would be concerns, as I said, with logic that approaches sort of treating acceptance of responsibility as a standalone factor, and particularly on this factual record where what happened is true. The IPA court did not credit Mr. Scott's recantation, but recantations are viewed with suspicion. There's no physical evidence, no DNA, no video, none of that sort of objective evidence tying GD to the crime. I think it's particularly troublesome on these facts, but it's not an argument that in no case could the court sort of grapple with IPA litigation in the context of an IRA case.
One last question, and that has to do with sort of how we review these cases. You don't, you know, there's not a lot of arguments that have been made in this case and others for sort of a harmless error review, but is harmless error a consideration that can be given in these cases when you have a multi-factor test and discretion can be weighted in any way the trial court feels appropriate, as long as they are weighing the factors that have been set out by the council in the IRAA?
I think that this court really only has to look back to Johnson and the way this court in Johnson talked about abuse of discretion. And here, because it's true both that the court relied on improper factors and that these improper considerations played a significant role in the order and the denial of relief, that's a sufficient basis for reversal, to the extent that courts, that some IRA cases have framed this as a harm analysis. I would just point out that the government has never argued that either of the errors that we have flagged are harmless. And I just think it's quite plain on this record that, especially when it comes to the youthful criminal history, that played such a massive role. The judge herself said, I can't emphasize enough that that's playing a massive role in the bottom line to deny relief. And so reversal.
The remedy that you would ask is outright reversal, or that we vacate and remand with instructions for the court to do what?
So we do actually believe that this is a record that would sort of, as the court in Johnson said, leave but one option that the court could choose without abusing its discretion. And that would be a basis for this court to order immediate release. But we would also accept a remand for reconsideration. And I think this could be as simple as a remand under Bryant, sort of as Bryant said, we remand the case for, proceedings consistent with the opinion in Bryant. I think that Bryant really squarely makes clear that these issues with youthful criminal history can't be playing a role. And so I think, again, something as simple as an order remanding for reconsideration in light of Bryant would suffice.
Thank you. And I know you reserved a couple minutes for rebuttal as well.
Thank you so
All right.
much.
Please the court. Alan Darby for the United States. This court should affirm the denial of appellant's IRA motion because the lower court properly considered the factors for and against resentencing and did not abuse its discretion by reasonably concluding that appellant had not both established non-dangerousness and that the interests of justice warrant resentencing. As an initial matter, we agree with appellant that when looking at an IRA motion, when you're gauging a movement's rehabilitation, you have to have a baseline set of facts in order to show personal growth. And that's precisely what the lower court did here. The lower court looked at factor 2, the history and characteristics of the defendant. It noted any red flags. For instance, drug abuse in movement's motion below. Appellant specifically stated that his life spiraled out of control because of his drug abuse, and in its order, the lower court said that drug abuse played a seismic role in his life past the age of 9. It looked at his history of violence as a baseline from his juvenile criminal history to now, and it looked at his general propensity to disobey orders from his history and characteristics, till now. And what did the court find? The court found that appellant is still abusing drugs. He has not shown personal growth in that area. In 2022, he was sanctioned for the use of drugs and alcohol. In 2017, he was sanctioned for possessing drugs and alcohol. It looked at the violence of appellant. In 2006, he was sanctioned for assault without serious injury. In 2015, he was sanctioned for fighting. And then
So you seem to be rewriting this opinion in a way that's very favorable to the government and favorable to sustaining it, but doesn't sound anything like the order that I read. Where are you getting this comparative analysis where the court is actually looking at it, establishing a baseline, and then actually making the analysis that you seem to be agreeing with the government, agreeing with the appellant, should be made, which is, all that aside, that's the baseline, that's what got him here. Now let's look at and see whether these other things that have happened in his life since his incarceration have made him, 1, not dangerous to himself or others, and 2, in the interest of justice based on that, someone who should be released back into the community. But the order doesn't read that way. The order reads as more, at least in my opinion, not commenting on my colleagues, but more in the nature of, because of all of this, he continues to be a danger. Isn't that a more fair reading of this record than the way you're arguing it right now?
Respectfully, Your Honor, no. And I would like to turn to the actual language of the order. If we look at the record at 419, this is the order at page 21. The text and the structure of the lower court's dangerous analysis is saying exactly what I have just said. You begin with the significant negative of the history and characteristics of appellant. And then the court explicitly says after this history and characteristics, realistically, his path on the outside will be challenging, and he has made very little effort to prepare himself for that challenge. He has not given himself the tools to seize the moment. And then it goes into the lack of programming, the continued infractions. And at the very end of the court's dangerous analysis, the very last paragraph, it says the defendant's lack of programming and his continued propensity to disobey rules. That is what gives the court concern, that he will fall into familiar paths, the history and characteristics of defendant. And in regards to appellants and this court's concern with Bryant, it is the government's position that Bryant is clearly distinguished on these facts. At the outset, Bryant makes explicitly clear that a trial court can take into some account a movement's juvenile criminal history. And so what is sort of that line? And I think Your Honors were alluding to that. What is sort of the line? And the court makes clear, Judge Steele made clear, it's when the juvenile criminal history becomes dispositive under factor 2. such that you can weigh factor two against the movement.
But dispositive of what? I mean, what is it about juvenile history that bears, if you have someone that has achieved X level of rehabilitation and lack of dangerousness, and we can quibble about where X is for this particular defendant, but what difference does it make what they did 40 years ago with respect to whether they've achieved X level of rehabilitation and lack of dangerousness? It doesn't make sense to me.
If I'm understanding Your Honor's question correctly, and please correct me if I'm not, sort of what the trial court should not be doing is looking at the history and characteristics of the defendant, but then seeing the significant negative of juvenile criminal history and saying, I will weigh factor two against, dispositively against the movement, which is contrary, the court notes, to the purpose of IRA, which is to take into consideration sort of the impetuousness of youth, to weigh juvenile criminal history so heavily such that you're weighing the history and characteristics against a movement. That's completely contrary to IRA. And if you look at the lower court, the trial court in Bryant, what the trial court actually did, if you looked under the factor two findings, at the very end it says, and because of these reasons, we weigh explicitly, we heavily weigh factor two against relief. And then if you look at the trial court in Bryant's analysis under factor two, it's like here, it found factor three against, found factor three weighed against the movement. But then it also said that factor two heightened that weight. To find juvenile criminal history dispositive under factor two and then weighing that factor against the movement, that's the error. And under these facts, Bryant is distinguished. The trial court here did not say that factor two explicitly weighed against the movement. And it did not make a finding that the significant negative of his criminal history is why this court is denying relief.
It's very hard to read this order without a through line, seeing a through line of holding GD's juvenile history against him consistently, whether it's with respect to specific factors or, again, a through line. As Judge Washington said, you seem to be reading a different order than I am.
Your Honor, I would agree with you. There is a through line, but the through line is the specific instances of a baseline set of facts, the drug abuse, the violence, the propensity to disobey rules while incarcerated. That is a through line that shows a lack of rehabilitation, that shows a lack of personal growth. And I would like to also note that in terms of the general propensity to disobey rules, appellant sort of was sanctioned for 8 infractions since 2015, since the age of 35.
There was also information in the record about appellant's efforts to mentor other inmates. There were a number of positives, as I asked appellant's counsel, that the trial judge refers to. And it's not clear that she gave them much weight at all, even though more of those factors by her own order seem to weigh in favor of release. And we see sort of, I use the word harping on what the defendant did at age 9 in his juvenile childhood years. And we're now, for IRA, need to be focused on the present and what the likely outcome is if the defendant is released. And so it's concerning that she didn't seem to spend a lot of time on his pattern score, which is the assessment that the Bureau of Prisons uses to determine the likelihood of recidivism. There's not a lot in the briefing about that. She seems to ignore the low risk pattern score, and she talks a little bit about the fact that he's in a medium security facility. So I don't see the information in the record showing that she viewed childhood as a mitigating factor, which is what IRA is supposed to do, and that she really was focused on other factors, as you're saying.
So, Your Honor, I believe there are two questions there. The weighing of the factors and then the pattern issue. With regards to the weighing of the factors, The trial court did exactly what it's statutorily required to do. It was tasked with considering these enumerated factors. It did so at the very end. In its conclusion, the trial court said, based on the aforementioned factors, the court is denying relief. So we believe the trial court did not err there. With regard to pattern,
I forgot what pattern stands for, the exact letters, but it's an acronym.
it's a score to show essentially the risk of recidivism when entering the community.
I mean, I understand that, but I couldn't remember what each letter in pattern stands for, but.
I'm not quite familiar what the actual acronym stands for. I will say the court certainly did not abuse its discretion in not considering it or weighing it. I would also note that the court may or may not be aware there's ongoing litigation.
Wouldn't that be more significant? That his pattern score as assessed by the Bureau of Prison experts evaluating his likelihood of recidivism, wouldn't that be a significant factor to weigh more so than what he did as a teenager or a child?
So, Your Honor, I would initially state the pattern score itself does not go to a specific factor. It goes more broadly to the determination that the court is tasked with making, whether or not the movement has established non-dangerousness or that the interest of justice warrant resentencing. I can say, though, that if the court could take judicial notice of sort of the male pattern risk scoring that is available online, and it goes through the categories that the BOP is using to analyze and assess this factor. It goes to age, the offense, a history of violence, education, drug use, incidences, programs, work programs.
So you're asking us to go behind BOP's assessment of a low pattern score and look at the bases as to why BOP reached that score?
No, Your Honor, I'm simply stating that the court cannot offset its responsibility under the statute and give weight to this score. I would again like to circle back to the fact that there is ongoing litigation regarding this pattern score, specifically the protocols within our office when it comes to compassionate release and IRA motions.
Can I ask you, sorry, please.
No, I don't know if you were going, but I'm really about to piggyback on an earlier question of yours, Judge Shanker. So we're not supposed to sort of look at things that could impact, the court should not look at things that should impact or could impact the decision on somebody's dangerousness if released from prison, but can look back to when they're 9 years old and draw conclusions from that as to their readiness to rejoin the community.
My answer, Your Honor, would be that it is our position that it would not be an abuse of discretion. But again, I'm sort of unsure about how to answer your question because of this protocol within our office about using the pattern score. Specifically, we state in our revised procedures that the defense may report and rely on a low or medium pattern designation. The U.S. Attorney's Office agrees that it will not report or rely on a higher medium pattern designation. In formulating these policies, we agree not to report pattern scores which we understand to preclude us from reporting or otherwise arguing about defendants' pattern scores in both the compassionate release context and analogous IRA sentence reduction proceedings.
Counsel, sorry, I don't mean to cut you off, but I realize there's kind of two big issues here. One is the juvenile history. One is the reliance on the IPA motion, which we haven't even touched on yet, and I think we would like to. But there are a lot of things in this order that give me pause that I'd like for you to answer. One is this mischaracterization of the drug report as being outdated based on incorrect information. Number two is this reference to the fact that this individual should not be entering people's homes if and when he is gainfully employed after being released, which is based on nothing, nothing in the record. It's not based on the nature of his prior crime. And number three is, well, I've forgotten number three, but I'll remember it if you can answer those two, please.
With regards to the first, with regards to, if I remember correctly, the outdated drug assessment. The court did note that this drug assessment was not dated, and there was a question about what BOP facility he was in. However, the court did note that as recent as August 10th, 2023, the BOP scored appellant as a medium risk, classified his living skills as poor, and assessed him negatively for drug and alcohol abuse despite his completion
Right,
of
but
the
this,
drug
let,
program.
but this report or analysis followed that 2023 violation, right? Am I right? Or maybe not.
I don't, if my memory serves me correctly, I do not believe that is the case, Your Honor. But,
I did remember my third one,
hey,
which is the reference to lack of trauma, which is directly contradicted by the mitigation report filed by the defendant without any finding that that mitigation report was wrong.
and so if I remember your second question, it was regarding the home employment opportunity. That's something that it was dicta in a sense. It did not sway this court's determination about whether or not to grant relief. The court was clearly looking at factor 3 about his lack of programming and about his failure to establish non-dangerousness. In regards to the third question, could you remind me again, Your Honor?
Yeah, the finding that he had not suffered trauma as a child, which was directly contradicted by information in the mitigation report.
So there was discussion within the court's order about the sort of conflict between the pre-sentence report and the motion below. Again, I would,
Well, I'm not talking generally about the nature of his upbringing, but specifically suffering specific trauma. And there was reference, which I will avoid, putting in open court now, but to specific incidents in his youth that would seem to contradict a finding of lack of any trauma.
Your Honor, that finding, again, two things regarding that. I would again say that that's not the basis the court ruled on the motion below. And second, under the history and characteristic.
You keep saying that's not the basis that the trial court ruled on, but that's in the trial court's order that she considered it. And I guess the challenge that we have is trying to figure out what weight she's given to these various factors and whether she's weighed them improperly in light of things that happened when he was a juvenile.
So again, I would sort of, to answer your question, circle back. This goes to the history and characteristics of the defendant of the movement, which the court did not weigh against relief. And I know the court has some contention with the reading of the analysis in factor 3 and factor 2 and how there's a baseline set of facts, but that would be my answer, Your Honor. And if there, regarding the dangerous analysis, if there are no further questions, I would like to turn to the interest of justice analysis briefly. As an initial matter, that this court has said in Doe that the interest of justice analysis is sort of combed in by the enumerated factors within IRA, but there is no rigid rule or rigid definition for how to apply it. And so the question before this court is whether or not there was a firm factual foundation for the court to hold the finding that there was a false statement relied upon in the IPA affidavit, whether or not appellant put on testimony, demonstrably false testimony, and then proceeded to an appeal. And as a general matter, the government's not arguing for a per se rule for someone who's sort of claiming actual innocence. That is something that's very common. It's less common to put someone on the stand and testify falsely. It's even more egregious to proceed to appeal into a decision. And
That last part seems clearly wrong to me, when all parties have appellate rights that we provide statutorily. Putting that aside, your position seems to prove too much. I mean, at some point, any defendant who files an IPA application has to assert actual innocence, has to do two things: assert actual innocence and provide some evidence, that perhaps new evidence, whatever it is, that they think proves their actual innocence. They're not always right about that. They lose quite frequently. But whatever evidence they put on, whether it's testimony or documentary evidence, or here's some sort of credit card bill showing I was in a different city when the crime happened, whatever it is, if they lose their IPA application, necessarily someone at some point has found that that evidence was false. How is that not, I mean, you seem to be saying that that can be held against them in an IRA application or not?
So, Your Honor, it certainly is not a positive. If we look to this court's decision in Doe, you have to look at the specific facts before the court. And so the specific facts before the lower court, looking at Judge Broderick, who also presided over the trial, you had this video deposition attached to this affidavit of someone who was profusely sweating so much he had to sop it up with napkins, so much he had to put on a jacket to hide the sweat. He obviously did not, he was nervous, he was fidgety, he was having trouble answering questions. And so he filed the affidavit, filed the motion.
But so I mean, you're saying that because he was a bad liar, that's worse than someone who just lost their IP. I mean, someone who lost their IPA application necessarily at some level, I use this term colloquially, falsely claimed their actual innocence based on some evidence that they think proved their actual innocence. I mean, a court essentially found that. How is that made worse simply because the person they put on the stand got very nervous on the stand? I just don't understand your logic.
So it's rooted directly in the IRA factor, specifically factor 5 as to maturity and rehabilitation. It does not show maturity and it does not show rehabilitation.
But my point is that, and I won't belabor this, I know my colleagues might have other questions, that you seem to be, what you're saying would always be the case with someone who filed an IPA application. That they're maintaining their actual innocence does not show maturity and rehabilitation because it is inconsistent with them accepting responsibility, essentially, is what you're saying, which is nowhere in IRA, I will add. But how is someone supposed to file an IPA application and at the same time seek IRA relief without running into the dilemma that you seem to be putting them in?
So to answer your question, Your Honor, I believe it's the fact that you're attaching a video deposition that is demonstrably false to the claim of actual innocence. And then you're putting an individual on the stand who.
What if you put in a credit card bill that says I was somewhere else and the court says, I don't buy it? I don't know, maybe it was doctored, maybe it wasn't. I don't buy this documentary evidence that you put in. How is that different from what you're saying?
It's the insistence throughout from the motion, from the motion hearing to the appeal all the way to a decision by this court, where there was corroborated evidence supporting the testifier's trial testimony from, I believe it was Mr. Jackson and Officer Schrader. The government had a strong case it could proceed without the testifier's testimony. You had the fact that the testifier was sort of blaming this on a medical condition, this profuse sweating. That was not raised before Judge Broderick at trial. He was not sweating profusely at trial. And the fact that to so demonstrably falsely claimed that you did not identify movement before the trial when he in fact identified him 3 times. It's all of those factors culminating as distinguished from Your Honor's point of just putting a credit card statement saying that, oh, I was actually in Atlantic City during the time of the crime. And I believe for all of those reasons, the trial court certainly had a firm factual foundation to say that this person knew what they were attaching to their IPA motion was false. They were 34 when they did it. They were 36 when they put a individual on the stand to testify falsely, and they were 36 when they appealed this court, continuing to pursue that claim. And if there are no further questions from the court, we would respectfully ask this court to affirm. Thank you.
Thank you. All right, counsel, you reserve 2 minutes for rebuttal.
Thank you. First, the government's attempted distinction of Bryant falls flat. The court in Bryant was expressly linking the juvenile criminal history to the BOP records there too. That's the way the court was relying on it in its ultimate conclusion, saying there are numerous serious infractions, more serious than the infractions we have here. Those concerns are heightened by the lengthy and serious history of criminal conduct amassed prior to the arrest.
So counsel, what direction or instructions would aid the trial court in finding this line about what's acceptable reliance on juvenile records, if any? Because this is an issue that has come up as evidenced by Brian in this case and others. What is it that you contend the trial court is consistently getting wrong or missing here that could be clarified by this court?
I think Brian actually provides all the guidance that is needed. So this order obviously predates Brian. As in Bryant, the court went through, and Brian is broader than the government characterizes it. Bryant says over-reliance is a problem that is in tension with IRA's fundamental purpose. Brian also says factor 10 must inform the trial court's entire analysis. And so those things in Bryant are enough, as in Bryant, to say, try again in light of the Bryant opinion. I want to say that in Bryant, actually, it's clear that the trial court weighed factor 10 in Mr. Bryant's favor. And Bryant still said that factor 10 analysis has to inform the entire case. Here, it's not even clear that the trial court weighed factor 10 in GD's favor in the factor 10 analysis. The court is talking about the acts being violent and senseless. That has no place in a factor that must weigh categorically in favor of relief. When the government talks about the BOP record as a way to sort of linking it to the reliance on youthful criminal history, I think there are a couple points there. Both, that is exactly what is going on in Bryant, where this court reversed. And when the government is talking about being assessed negatively for drugs and alcohol, the only negative assessment, again, it goes back to the needs assessment, which is just that one of the needs is drug alcohol use to further reduce recidivism. Also, as Judge Schenker pointed out, when it comes to the court's view of the drug infractions specifically, that rested on a clear factual error about the timing of the drug treatment program, which the court said happened in 2017. It actually happened in 2022. That affected both the court's view of the disciplinary record and the court's view of the expert letter. In addition, when it comes to the BOP record, to the extent the government is now relying really heavily on the disciplinary record, another thing that the trial court here failed to account for, just as in Henney, was an expert assessment that the disciplinary record, quote, does not correlate to community dangerousness given the behavior and context of the data reviewed. That's in the sealed supplemental record at 146. And so I think the errors here include both the Bryant errors in over-reliance and improper reliance on youthful criminal history, the reliance on arrests and dismissed charges that is clearer here than it was in Bryant, the reliance on unsupported perjury findings in the IPA litigation, treating maintaining innocence as a standalone
When you say
factor.
unsupported perjury findings by the trial court, there was support in the record that she pointed to for why she made these perjury findings. But is your argument there similar to the point that Judge Schenker was making and asking of government counsel?
Yes, I think our point is that there were no perjury findings in the underlying IPA litigation, and there's really no record basis to say what happened here was perjury.
He talks about the witness, Scott, I think it was, demeanor on the stand, sweating profusely. You know, usually those are the kinds of credibility determinations that we would credit by a trial judge. Why wouldn't
But-
we credit those determinations here if the judge is looking at someone on the witness stand and doesn't believe what they're saying?
I think because this isn't Mr. Scott's IRA motion, right? And so if Mr. Scott perjured himself, which Judge Broderick never said that he did, that's not the question. The question would have to be, and GD knew that in order to find subornation of perjury. We've pointed to the federal sentencing context where it's clear that those things can be considered, where the Supreme Court has said, you know, those sorts of determinations have to be made by the judge who was actually observing it. You couldn't sort of make a subordination of perjury finding on a cold record, much less without any record evidence showing any connection between GD and whatever the testimony is. So the fact that it wasn't credited doesn't say anything about GD. Again, the only thing personal to him was signing the affidavit that all IPA
I
move-ins.
mean, you
have
seem to be
sign.
hanging a lot on whether this met the actual elements of perjury and whether the IRA judge could be making that sort of statutory element finding, which is perhaps right, but it does seem to be, I mean, at some level, I think it's fair to assume that GD had some role to play or some decision-making, or at least his counsel did, in presenting the testimony of Mr. Scott. So I would think, and I'm not, it's your argument to make, I would think that the position should be that anyone who claims actual innocence in an IPA petition has to put on evidence of that. And if that is rejected, that can't be held against them in an IRA application. But explain to me why that's not the position you're taking.
So that is my position. I think that we have relied specifically on the characterization of perjury because I think that's how in the trial court's mind, she was distinguishing this from just a case of punishing someone for not accepting responsibility, was to say, but there's this separate crime of perjury. So we take issue with that. But the broader point, as we've outlined in our pleadings, is that the logic here would, as Your Honor says, sort of pit the IPA and IRA against each other. And so I think it would suffice to the extent that the court reaches the IPA and interest of justice question on remand, which I don't think is necessary to do. It would suffice to sort of remind the trial court that maintaining one's innocence is not inconsistent with IRA relief. Also, when it comes to the interest of justice analysis, there's a Doe-Riley error in the court talking about the seriousness of the offense, criminal history, and provided for just punishment. That's error under Doe and Riley, which also postdated the briefing in this case. There are the numerous examples of discounting relevant evidence without explanation. That includes the low pattern score. That includes the expert assessment about the BOP record not corresponding to community dangerousness. That includes the evidence of the traumatic childhood. The court is saying there's no evidence that GD struggled with his father's absence while disregarding an evaluating psychologist saying when he was 13 that there are unresolved issues of abandonment. There's the clearly erroneous factual finding about the drug abuse program. And so
we hear your
Yes.
argument, and
Certainly.
we thank you for your argument today, and your time is expired. Thank you very much. We thank both counsel and parties for your arguments and briefs today, and we will take the matter under advisement.